Law, distinguished faculty members, distinguished guests, students, and friends. I profusely thank Lord Subramania. He has got so persuasive skills that it is very difficult to say yes to his request, and it is impossible to say no for his request. Therefore, after several attempts and several postponements, and today I think we both are successful. Rather, our respected dean was successful in hosting my lecture today. I'm indeed very grateful to you for a very generous introduction. And today's theme, as I think I have told it, is democratic constitutionalism. It is nothing but old wine in new bottle, but it's only nothing but a liberalization of constitutionalism or renaissance of constitutionalism, in a sense that we have to see and find out the difficulties, particularly in bridging the gap, as I think the foundational myths, as Walter Benjamin says, and also the lived realities as per the constitutional concerned, and also the various incarnation of illegalities and unconstitutionalism. And here we are making more or less a pedagogic violence, or it is a pure academic discussion as distinguished from other violent discussions. Anyway, coming to the basics now. Constitution and constitutionalism. I hope you are well aware, but constitutionalism and constitution are such concepts that one we can say broadly a text, the other one we can call it a context. And the text constitution may be there, but constitutionalism may not be there. And at times, constitutionalism may be there and constitution may not be there. The finest example of where the constitution was there, that in a written form, and there was no constitutionalism when you take into consideration particularly the Nazi Germany. As the familiar examples with UK constitution is that there is no written constitution, but there is a constitutionalism. So now what exactly you mean by constitutionalism? And some people say that no, constitutionalism is nothing but a rule of law, or that is against arbitrariness. There should not be any arbitrariness. So here we came across some of the most important attributes of constitutionalism. What are the attributes or main ingredients of constitutionalism? One, of course, is that the most important one is the supremacy of the Constitution. Here when we discuss about the supremacy of the Constitution, and we have where from we got the Constitution, and here we have got we the people of India. Well, friends, this is the source and this is the beginning of today's lecture. If you very carefully examine the preamble of the Indian Constitution, which in fact is nothing but the philosophy, the spirit of the Constitution, and the conscience of the Constitution. If you read very carefully the words, and if you can follow also in between the meaning of this one, we have started our preamble. We, the people of India, do hereby solemnly, whatever it is, declare and constitute. That means we are establishing. So we are constituting, we have established, of course, what? To see that we establish a polity, and this polity, the various things are given like sovereign, democratic, republic, and all this. After that, they said that this is the spirit with which now we establish, and we have to fulfill the following things. The first and foremost is secure justice, social, economic, and political, and to secure liberty of thought expression and so on, and to secure equality. So, justice, liberty, equality. Please follow me carefully. The next one is that since we cannot secure, but what we want to do is promote fraternity, promote fraternity, and then assure, assure individual dignity, dignity of the individual, and unity and integrity of the nation. So, well, friends, the key words here are one, justice, then liberty, equality, three, fraternity, dignity, and nation. These are the six the key words of the preamble, and this is the actual philosophy. And herein lies now what we call the democratic constitutionalism. And about the three things now which are to be secured, that is liberty, obviously this justice, liberty, and equality. I am not going to the sources from which we have taken, but fraternity and dignity. And without fraternity, you cannot assure dignity. Of course, it's also the reverse. Without assuring dignity, you cannot have the fraternity also. Fraternity and dignity are such. Without that, in fact, we never had also a nationhood. So, nation can be built only on this fraternity and dignity. These are, friends, we can say, these are the goals. So the secured ones are the three, and the other three are to be secured, and it is a constant, the dynamic, the organic process to promote fraternity, to assure dignity, and also to build a nation, or rather, unity of the nation as a whole. This is the crux. And now constitutionalism, I have told you, broadly, number one is about the supremacy of the constitution. Second, the most important constitutionalism presumes is that it is actually representative and responsible government. Representative it may be, but it must be responsible government also. And the third is dispersion or distribution of powers. And this also, legislative, financial, and administrative powers. And then protection of individuals, that is through part 3 and part 4. And fifth, that's most important. Hello? Any disturbance?
Yes, you can continue.
The fifth and most important is about the creation of politically neutral zones. The creation of politically neutral zones, particularly in a democratic country like ours, is, we can say, a very innovative step as far as the Indian constitution is concerned. And here you see there are two types of politically neutral zones. One is that these institutions have got no coercive power to see that see what they decide is about followed. That is number one, a judiciary which has got a coercive power, and also the election commission. Both are politically neutral zones. In addition to that, we have some other offices, particularly the Office of Attorney General and the Office of Controller Auditor General of India, which is a quasi-judicial authority. And third is the most important is civil services. The common civil services are all India services. This is in fact to see the backbone of the constitutional democracy because they are to be politically neutral. So these are normally considered as five important elements no, to ensure constitutionalism. But now we see the present day, we are running into what we call, I can say that it is, we are facing what we call the so many contradictions as far as this constitutionalism is concerned. And these contradictions are, broadly speaking, a, see, what all we want is that we want rule of law, but we do not want to be ruled by law. We want constitution, but we don't want constitutionalism. We we want freedom, but we don't want freedom to others. And we want equality, but we do not want equality to others. And we want dignity for ours, but we don't want to give dignity to others. And we want no fiscal federalism or fiscal autonomy, but we do not want fiscal discipline. And what above all, we want welfare. Everybody wants welfare, but ours is a welfare state. State comes first and welfare later. But we want only welfare, and ultimately the state will disappear. There will be only welfare and no state. And above all, we want justice for us, but we do not want justice to others. So these are some of the contradictions now which we are facing. And now the problem is with our constitution, constitutionalism, we can say, broadly speaking, we can put it to see this. Uh, we have different aspects, or we can say different incarnations of constitutionalism. Over time, we have seen the constitutionalism in various perspectives, and varies from time to time. And this, of course, depends upon the interpretation. Interpretation of the constitution is always by two ways. One, of course, to take out the original intention. This is as rigid, and this is nothing is flexible. But other one is what the Canadian Supreme Court, and thereafter other jurists also uh, have approved it. That is living constitution, living tree constitution. It is an organism. It is an organic growth. It is not a dead letter. So by this way, the constitution grows, and the process of its growth, it takes several incarnations, or what we can say several avatars. Several avatars like Matsya Avatara, Kurma Avatara, Vamana Avatara, and ultimately sometimes Bhasmasura Avatara also. So how it comes, from various phases, how it started, it depends upon several factors. And friends, here I would like to tell you, it is not constitution is not a modern concept at all. It is something which we have been accustomed to this one, and this for this we need not have to borrow or only look at, see, either Rome or Greece. Constitutionalism was in our country, and in fact, see, if you make a thorough research, particularly see, for Shastra, which was written see, somewhere about see, 400 BC, where you see, it was considered the most secular you see, code as far as the world is concerned. And at the Shastra, and you see, by that time, you see, a well-established governance also was there. And see, the idea of constitutionalism has developed as far as back in 375 BC itself. And if you can see the political economy or see Arthashastra written by Chanakya or Kautilya, it is an ample see, manifestation or demonstration see how constitution has flourished in this ancient Indian land. We never believed in the divine origin of all these things. We have you see always the believe you see in one concept, that is dharma, which is all pervading. And this dharma is the science of sciences and the arts of arts. And this is so flexible, at the same time strong enough. And like our constitution is also equally strong, and at times it is also flexible. In fact, this is Dr. Ambedkar ji has made this see, on 25th November 1949 itself, saying that our constitution is strong enough, and at the same time it's also flexible enough to change according to the needs of the people. Remember, of the people, because the constitution is meant for the people, are we the people. So this has been there, and the entire see, edifice of the entire see, governance in the ancient India. In fact, the first see expansive and see almost see which has covered all over the subcontinent of India, right from see Afghanistan up to Southeast Asian countries. That is only Magadh Empire. So during that time, Magadh Empire, the principles which Chanakya has adopted through the Upanishads and all these things, he has said that Kshatrasya Kshatraha Yad Dharmaha. Kshatrasya Kshatraha Yad Dharmaha. Dharma means, again, you can take law. Law is the king of the kings. That means there is no king like the Austinian sense. There is no king as such. And there is the Kshatrasya Kshatraha. Yad Dharmaha means law is the king of the king. Even king also is subordinate to the law, which is absolutely contradictory to the British constitutionalism, where British monarch for a very long time, almost up to 1948, the king can do no wrong because he is a divine person. So our secular concept, see, and also see a democratic constitutionalism, that is rule of law, was very much embedded, you see, in our see, ancient culture, see, and right from see, at least the known history, that is 375 BC or see, Sarkai. So this is a most fundamental one, and if you still further go deep into this one, so here you see how the state and the law has got to see a very distinct see nature and characteristic features also can be seen that is, if you can go into the historical past, you can see Chanakya was a student in Takshila University, which was some 6,000 miles away from Pataliputra. There he studied political science. They are not known as universities, they are multiversities. It is not one discipline, there is made to see, study almost all disciplines, including see, warfare, see, military science, and all these things. So he was trained and then he became a professor there of political science. And it is he who has made, see, he has become see, more see, pragmatic to see and see, to arrest the onslaught of Alexander the Great And for this purpose, no, he at that time only thought that India should be reorganized into one unified country. And it is possible only if there is a state and also if the state is bound by law. That was his main concern. Then he came back see, to Magadh or say Padliputra. He found see, a talent, irrespective of to what caste or what he belongs. He found see, one boy by name Chandragupta, and he took him with the permission of his parents and he took him to Takshashila. He got him trained there, and again he got him and he made him the king or emperor of Magadh Empire. And then you see when he wrote all Arthashastra, he told see Chandragupta that he was bound, he is the first servant of the people. He is the first servant of the people. So here what I would like to say is what he has laid down by way of law, it is abstract. It is abstract. What we can say it is Nirguna Nirakara. We also see, if you remember, see Kelson, Hans Kelson, a great see a jurist and also the person who has propounded the theory of grand norm and a person is a professor of international law. He himself said, you see, law and state, they are not two things. They are one and the same thing looked at from different angles. This was, see, very much pointed, this was very much a manifest in Chanakya's, Arthashastra. There is, he said, you see, law is abstract and the king or the state, it is a concrete one. So to give shape or see to give see concretization to the abstract rules, the state should be there. That is, you could see in king or kingship, or that is what no concretization of the law or see abstract norm. So this we can say Sadguna Sakara. Where there was nothing, you had given him a shape, and therefore you said he is the king. Here is the king, you can see this. Similarly, you also said there is a norm, and these norms are to be followed, and these are the legal rules, but they're abstract, they are nirguna nirakara. And it is nothing but see what subsequently this can be attributed to Kelson. And apart from that, now we see if we come to our own constitution, just see the similarities, or see, in fact, see the the coincidences that Article 12 and Article 13, they are so juxtaposition. They are so juxtaposition. Article 12C talks about the concretization of the state, and Article 13 speaks about the abstract nature of law. So 12 and 13 put together, one is they are see one coin, look at from different angles. If you look at from the Article 13 angle, it is law. If you look at from the Article 12 angle, it is the state. This is how we see our constitution framers also have juxtaposition state and the law. And state they have defined in Article 12, Congress, government, parliament, and all these things. And you see, Article 13.3 defines what see law is. And further coincidence also you can see Article 14. Article 14 is the crux of the entire constitution. And that you can see that is nothing but rule of law. The equality before the law and equal protection of laws. So this is nothing but rule of law or non-arbitrariness. And this is nothing but your constitutionalism. So here are see some of the things where you see constitutionalism is kept see intact. And now, how far and to what extent you see this constitutionalism we see almost as far as our see daily our reading or see in our see, governance we can see this. Our entire study more or less see we concentrate only in the courts and what the judges have said, and this is all you see what the prudence of the courts we can say what we call jurisprudence. Jurisprudence is mostly those principles, precepts, norms, and all these things which are made and developed by the courts. And this is what we call jurisprudence. In fact, this has got a different meaning in Anglo-American societies. But in the European countries, no, it has signifies something else. That is, in Europe, it is known as jurisprudence of the court. What the court now develops are what we call case law or precedent. They are known as jurisprudence of the court. This is the meaning of this one. But friends, now for a moment to imagine how much law is made by the judges or the courts. How many people will go to the courts? Of all this litigation, what about the other laws? So unfortunately, our pedagogic violence is that we talk so much about the courts and courts and courts. But much law is made beyond the courts. And this is what we call, this also is a type of knowledge. Knowledge of law, jurisprudence is not confined only to the courts and their judgments or their principles or their values. But beyond that, much of the law is made by elsewhere. That's why for a moment, let us let us not ignore, but let us just keep it aside. What is the contribution of others? And this, of course, now brings us to the recently coined some words like legisprudence and also demosprudence. Legisprudence and demosprudence. And here, the balance of making the law, particularly legisprudence, is the legislative lawmaking because much of the law is made by the legislature. The legislatures or the persons who are representatives of the people. So in a democratic process, they are elected and they make the law. And when they make the law, they do not make arbitrary laws. The laws are brought there and they have to survey what are their feelings, their representatives are there. And then that means they are creating a new norm. And law making is an important and most crucial function of the legislature. Remember, not the courts. So therefore, the knowledge regarding the law making by the legislature or by the representatives of the people, that also has to be taken into consideration. Because nothing, constitution is nothing but it is applied politics. The political parties know which they represent the majority opinion. And then the bills are discussed some twice or thrice or sometimes the more times. Select committees are formed. And when the legislature is creating a new norm, it is subject to see a lot of discussion. Then only it is put to vote. And majority of the people they vote for it. Then only the bill becomes the law of this following the procedure, the executive signature. It's a long process only meant for this. So even assuming that for a moment the social contract theory of Rousseau and John Locke, by means of this one, the people have surrendered a little bit of sovereignty to the legislature or the king or the state. In return, that they have promised you there are certain welfare or certain rights which will not be touched, certain freedoms also. Like we can say that these are the three motives is it Palana, Rakshana, and Yogakshema. These are the three most important things. Prajahitena hitasya rajya. See the Rajya or is it Rajya or Raja or is it king or is it the state is mainly intended for Rakshana. Then Palana, governance, and third Yogakshema for the welfare. So the legislatures are meant to see that the aspirations of the people are transformed into laws, and these laws are to be conformed or to be obeyed by the people. So for a moment, you decenter law. There's a decenter court. See, we assume that law is just there. How that law has come there? As a jurisprudence, or see, as the people who are see more see court oriented, we think there is a law is there, but how it is there? That law has come see, because of the practical reason. It is not just see an arbitrary one. It is nothing but see a composition of practical reason. And this is no by way of see notional contract, no social contract, which the people have established no, by with the rulers. And rulers in turn see have guaranteed and given guarantees that they should not interfere in these things. Having said that, this is what we call, this is what is the ruler or the king, he gets legitimacy or his power is legitimized because of the social contract or notional contract where is the people have agreed. So here you see the people when once you see when they become you see rulers. In some cases, what they do is they become you see proxy because they think that you see they are exercising the will of the people because the ruler's will is the people's will. Tatha raja, tatha praja. It's not like that. But in some way, they say this is what we call proxy. By I am, my will is the law because people have entrusted this one. Therefore, I am, you see, the manifestation of the people's will. But that is not correct. But thereby he assumes a proxy for the people's will. This is what we call legitimacy. So he himself feels as he is legitimized to exercise the power or is he to put restraints on. The second aspect is more is a democratic one. Here again comes now your democratic constitutionalism. So in a democracy, people's voices also are heard, and you have to make the law in such a way so as to concede the minimum demands of the people. At the same time, it's without affecting the good governance. Therefore, this is legitimation, or we consider. So this is instead of saying see proxy one, it is what is the trade-off. Just like take for example, see Article 19. Article 19, I mean in a broad way, it is that trade-off. Right? You will exercise see all these freedom. You will have freedom of speech and expression. But that does not mean you can abuse others. So Article 19.2 is there. So the rulers and the rule they had cheap trade-off. Why we will give you this much, then we'll put you reasonable restrictions. So that is how we see this is called legitimation. So this is how we see legisprudence plays a very important role, which we unfortunately jurisprudence we ignore much about it. Then next is more important. The modern see things are now seized with what is called demos prudence. Demos prudence is nothing but see a wider concept of see democratic socialism. We can say democratic constitutionalism or constitutionalism is a broader concept, and demos prudence is the species of that one. Either way, demos is a Greek word. Demos is people, and the way in which people's intellect goes, and how see the civil society, and also the various people's organizations, how they are going to bargain, see particularly, and how they make the movements. Particularly, this of course now we can say partly seen the public interest litigations. See, public interest litigation, they are not cause lawyering. So individual pays no money to the advocate and the advocation of fights no tooth and nail and he takes the money and a rule is made, but it's only case oriented. But this public movements no, it is a cause orientation. That means you will change the legal culture as such. But it's globalization era. It has given rise to that one. And several see movements have started. The forest rights, then you see PILs, then you see water. So these are some of the basic issues which nobody will take up. But no lawyer will take up because there is no cause lawyering, there is no culture lawyering. So when these people see take up, it is here see this democracy, demosprudence. Out of that, see the 70 years have already passed as far as our Indian constitution is concerned. It has been working. Well, friends, those who are serious students, they revision what the court has done during the first 10 years, or first decade, second decade, third decade, fourth decade, or see first 20, first 30 years. So like this, if you see the various periods now, we can see makes each period as itself know a what we can say incarnation. So during you see during 50s to 60s, the static, it was a static body. It never is he bothered about it. He said, "You see, let the parliament do anything they like, except that they persuaded. It was a persuasive constitutionalism by the court to see that no property is protected." This went on, and the legislature was aggressively seeing that no property right as far as possible is reduced. Then in 67, you can see Golaknath's case. We can say this is a little bit no creative constitutionalism, where the court has come with the arguments no given by, and where the a brute majority is governing, and then property is not being, because property is considered once upon a time as a very important one, but because the socio-economic conditions of the India, then the we have also acquiesced in, and therefore property has become no longer relevant. But at the same time, persuasively the court has it is persuasive avtara of court. But in 67 with Golaknath, suddenly the court has raised its voice, saying that no, the brute majority should not work like this. And one which is proper to a person is property. And the dignity is linked in the presence with the property. Therefore, they linked it, and then ultimately it has ultimately resulted into the denial of power of the constitutional amendment in Golaknath case. Then came Keshavananda Bharati's case. This is what we call creative constitutionalism. It has come from nowhere, we don't know. But they have seen, right from 1950 to 1973. They went on to see what they see, what the legislature said, what the parliament has said, they completely acquiesced in, or we can say that in the name of in the name of the people have acquiesced in. Therefore, they have upheld the constitution amendment power of the parliament. Constitution means you are creating a new norm. When you are amending the constitution, that means you are putting an end to the earlier norm and you are creating a new norm. So 73 has seen a very important, and you can say either innovative or creative constitutionalism, whereas you are given birth to a new principle, you have created new norm by saying it's the basic structure doctrine, and even Parliament also should bow down before that one. This is the real rule of law, in the sense that even the organs now which are constituted under the Constitution are also subject, because this is what we call interdisciplinary ones. Intergovernmental organizations also must feel that they are bound by what we call constitutional maryada, constitutional courtesy. This is what sometimes the people call Lakshman Rekha and all these things. So here the constituted bodies, they must always be within their limits, and therefore that is how they are. Now, friends, after this creative constitutionalism, the year 1975 came. It is most unfortunate, we can say, we have destroyed our own constitution. Our own Supreme Court has become Bhasmasura. All your liberties have gone. Here, please remember, the constitution, we the people have constituted this for securing justice, liberty. And by 75, ADM Jabalpur Shivakanta Shukla's case, what they have done? All freedoms are buried, and all courts 32 and 226 they have closed. And for 19 months, people were actually kept in darkness. This is nothing but it is most undemocratic, and it is nothing but destruction of democratic constitutionalism. We have indicated all these things, but it is the real what we call demos prudence. How the movements know they change the law and how they affect the democratic institutions. Where you see they are totally shattered. And when the next government came, it is people who have voiced that all their liberties were buried. Then came 44th Amendment. 44th Amendment is nothing but it is not jurisprudence, well, friends. It is demosprudence. It backed legisprudence that resulted, see, in the again, you see, constitutionalism. This is what I can term as democratic constitutionalism because they are all liberties. And I started with myth and living realities. Lived reality. Lived reality, you do not have a habeas corpus. You do not have freedoms. They are the lived realities. Your myth is, yes, we have a constitution. What is this? Redemptive constitutionalism. Right? We have a faith in the constitution. Our faith is lost. Our faith is lost, both by the judiciary and by the. Then who is there to give us risk? Then demos prudence, the people's movement, and the particular significance of this people, they won't revolt by themselves. They make, see, the institution judiciary, they make the judiciary a partner, and they made the judiciary itself to speak. And this is what they have done in a doubly conscious manner in Maneka Gandhi. So they have gone beyond and beyond the constitutional mandate. Remember, the constitutional mandate specifically says Article 21 procedure established by law, giving Parliament supremacy. But the court has gone not because of the because constitutional spirit and demos prudence and thereby democratic constitutionalism won the hearts of the people, judiciary. So instead of going on to the streets, they made the judiciary an institution to speak for them and to say that the fair, just, and reasonable. That is how the substantive due process was brought not by the constitutional framers, but by the people themselves. This is post ADM Jabalpur's case, and they made it to see the court to pronounce this. This is most important. So thereafter, again you see our great Supreme Court. It has immediately woke up from the slumber, or the self-inflicted sleep, Kumbhakarna. So this Kumbhakarna suddenly got up and said, then from 1978 onwards, from Maneka Gandhi, from Minerva Mills case and all these things, it went on progressively. So the articles are there only. There are no amendments. But the entire constitutionalism transformed. It has totally transformed. Article 21 remained like that only. But they have made in such a way in Unni Krishnan, then you see this Mohini Jains, in all these cases, they made ultimately decent life. What is decent life? They themselves described good education. Then in fact, see this demosprudence, or see democratic constitutionalism has compelled the parliament to make Article 21A as fundamental right. You see, that is the power of demos prudence. And this is what is also democratic constitutionalism. This was not by court, a people. Then comes your creative constitutionalism. There is also what is known as creative constitutionalism. See, transformative we have seen that which is there. But at times, we also find that the courts also often they overact, and sometimes uh, I mean they forget about their institutional responsibility and institutional responses also. Take, for example, I think you're all familiar with Bommai's case. Well, friends, I mean, a cursory glance of Bommai's case, it is purely the executive has made a proclamation, and the proclamations in all is six proclamations. Three are about Karnataka, Nagaland, and Meghalaya. The other three are Himachal Pradesh, Rajasthan, and Madhya Pradesh. All six were totally proclaimed 356 under this breakdown of constitutional machinery. So, to revoke the proclamation and to say that proclamation is unconstitutional, see the category of reference now the court has taken, that is against the federalism. Therefore, see, Karnataka, Mizoram, this Meghalaya, and Nagaland, they said, see, applying the principle of federalism, and federalism is a basic feature. Therefore, see, it has violated the basic feature. Therefore, presidential proclamation is unconstitutional. That is how they have declared, and they have revived the assemblies also. Well, friends, for a moment, I'll ask, federalism, where it is written is a basic feature. You see the entire constitution. Ek bar nahi, 10 bar dekhiye. 10 times you see that. Word federal is nowhere there. And we have copied the entire thing from Government of India Act. Government of India Act, you see, entire thing is federal only. So deliberately we have avoided federal, particularly because the onslaught on 14th, 15th August 1947, because federalism will not suit us. Therefore, see, all that is ultimately unity and integrity, unity. India, that is Bharat, shall be a union of states. Originally, it was to be named as United States of India. No, Union of States. See all this entire thing. But suddenly the court in Bommai's case, federalism, they said basic feature. Because court said it's federal, therefore it is basic structure. But basic structure should be applied only in case of constitutional amendments. And proclamation of emergency is not a constitutional amendment. It's purely an executive order. They have, and for the other three remaining states, Himachal Pradesh and Rajasthan and Madhya Pradesh, because BJP government is there, though they are enjoying this majority, is it not contrary to democracy? Have you really kept up the democracy? And where from you have amended is brought in secularism as a what sanctity secularism has got now, because it has been brought under 42nd Amendment when there was no parliament, when there was no opposition. And this secularism is a basic feature. Therefore, see, we say that the proclamation is fair. Same case, same bench, and same proclamations. In one, you have said it is secularism because you want to deny the justice to them. Another case, no, you want to give them. Therefore, you said, see, it is federalism. Can you apply two standards for the same proclamations? I tell you, this is what type of, that means you are crossing the limits of constitutionalism. See, therefore, what we call constitutionalism also involves what we call constitutional morality. Constitutional morality, commitment to the constitutional institutions. And most importantly, reverence. This is what Deepak Mishra in 2017 has reiterated, because constitutional reverence is most important. Who will show the constitutional reverence? These organs. And above all, they must show reverence to the democratic institution, we the people of India, because we have constituted this constitution. Where are we? So this is how then This is what say we call also. I mean, these are various instances. That's why, in fact, you see, sometimes no, I see recollect uh, um the words of no, Dr. Ambedkar. I think on 25th November or so, he said, "Our constitution is strong enough. Our constitution is strong enough to fight against the ancient inequalities, and we are also flexible enough to imbibe the fraternity and dignity of the individual." Where are these words? And further, he said, "We have done our best to bring the best of the constitutions to you. But if the constitution failed, it is not the mistake of the constitution, because the man is vile. Man is vile, Vile. Vile means you can understand, number means are niche, dusht, wicked, cruel, everything. And it's not man, it's also institutions. Thereby he said, no external force will come and say destroy us. This is what no 110 years before Abraham Lincoln said in 1838. Said disunited states. He has given the title disunited states, not United States. Disunited states. In 1838, he cautioned no outside power CV can ever destroy United States of America. They are United States. It's only we within, and we are going to destroy it. We are the enemies of our democracy. We are the enemies of our democracy. And exactly after 25 years, in 1861, the Civil War started. This prophecy of Abraham Lincoln has come true after 20 years. Exactly after 110 years, in 1948, 1838, Abraham Lincoln said, 110 years later, Ambedkar said, man is vile. We destroy our own constitution. And what is that they have done? Without creative constitutionalism is there. But in the original objective resolution, the word fraternity was not there. The word dignity was not there, because we attribute our entire preamble only to Nehru, objective resolution. There was no mention of that one. All these were see totally fake. It is Ambedkar. And then somebody asked Dr. Ambedkar, Dr. Baba sir, have you borrowed this from G. Jacques Rousseau, Liberty, Equality, and Fraternity? This happened in 1956 when he was about to embrace Buddhism in Nagpur. Then Dr. Bhimrao said, no, I need not have to take these lessons from Montesquieu and others or see Rousseau's. I had this concept from my Mahaguru, that is Gautama the Buddha, the God enlightened. And it is he who has was propagated Maitri. Maitri in Sanskrit. Maitri is much more liberal, and is much more than fraternity, much wider. And it is in Pali, it is Maiti, Maiti. So that is where it's because there is no accurate word for this Maitri. I put it fraternity. And further, she emphasized, I told you there are 6 key words in the preamble. That is justice, liberty, equality. These three we have achieved. Then promote fraternity, eschew dignity, and also nation. We never had the feeling of nation. For the first time in 1947, see, we realized that we Bharat as a nation. And this nation can be built how? First, eschew dignity. If you can't eschew dignity, and this you can assure because of fraternity. And fraternity and dignity only can build, see, a solid nation. And that is you can establish, particularly that constitute India into a sovereign democratic republic. That is Chodo. This is the significance of what we call democratic constitution because the ideas equally come from civil societies. All this entire law relating to PIL, where from it has come? It is people's movements, NGOs movements, or see the various agitations going on to see that the Supreme Court takes this one. If it doesn't take it, then ultimately they go to the direct conflict with the legislature. So this is what this is. In fact, I wanted to say, and I have. So that's why, in fact, see, some of the one of the judgments also where they said that it is Manoj Narula's case, where they said the constitutions constitutions are written with blood, not with the ink. Therefore, reverence. Well, friends, now I ask, within this constituted bodies, because constitutive, constitution, and constituted. After all, what is constitution? Is nothing but inter-institutional harmony. That is the spirit of constitution. Understand? And judiciary must keep in its own place, parliament in its own place, and executive in its own place. That is inter-institutional harmony. And reverence. Reverence is very important. You respect legislature respects you. And you respect executive respects you. And if this irreverence is not there, this is what I call Maryada. Constitutional courtesy. You demand, say, constitutional justice, constitutional courtesy. And if once this Raja Maryada is forgotten, Raja here is Praja, Praja Maryada. It is democratic Maryada, Praja Maryada. And that is where you have to give respect to the people and their democratic values. And that is there only your democratic constitution survives. If you do not respect this institution of democratic constitutionalism, or if you do not show reverence, constitutions are nothing. They will be thrown by means of revolution. Constitution, after all, if a revolution is successful, it becomes a constitution. If it failure means it is anarchy. So democratic constitutionalism is more important than your transformative and all these things. Because as long as people tolerate, it's all right. But also you have to respect the democratic institution, democratic spirit, and also democratic demos prudence. That is what prudentia juris, they must see that. And it is only through that we can have, a symbiotic existence. Well, thank you, sir. Thank you very much. Thank you. Thank you.
Thank you, sir. It was truly knowledge enriching. The way you explained on how important is the representative and responsible government and discussed regarding the importance of dispersion and distribution of powers, and finally regarding the constitutional dialogue which the courts have to observe in maintaining the harmony between the three organs of the government were truly knowledge enriching. So now we have a few questions from our fellow students which I would like to put up. The first question is, how far the Supreme Court has been effective in upholding the constitutionalism?
I have not followed. Please repeat.
Yes, sir.
How?
How far the Supreme Court has been effective in upholding the constitutionalism?
I have already answered it. Because if I say too much, I'll be subject to contempt of court proceedings. With Supreme Court, this is the whole problem. I have already indicated because I think you can understand what it has done. 1975, you remember, that is the case. And even recently also, it wants to make itself feel omnipresent, but it is not potent. COVID cases, you do this, do that, without having proper information. Vaccination and all these things. Sabarimala, I want to do this one. What norms are establishing? Can you do really governance? I mean, these are the things. See, if I ask, because these people are very VIPs, because very impatient persons, contempt, hall for contempt. So, Usha or Puja. If you ask me such embarrassing questions, please don't land me in jail. You got my point.
Yeah, yeah. Go to the second.
Of course, broad. See, this it has affected constitutionalism. That's all. It was very responsive to constitutionalism, particularly to people's democratic movements. It was very responsive. Okay. Oh, entire PIL. PIL is a best example of Supreme Court's response to the demonstrance or see constitutionalism.
So the next question is, why a constitutional framework is best able to secure the ideals of collective autonomy and individual dignity?
What autonomy?
Why a constitutional framework is best able to secure the ideals of collective autonomy and individual dignity.
Dekho, your puja asking, na?
The question was by the audience.
Okay, I'll ask you. See, there is no need for the collective autonomy. What do you mean by collective autonomy? If you say the entire governmental process and the constitutional governance, it is all see collective responsibility. See, collective responsibility because each institution is responsible for the other one. And that is, in that is, of course, if you say autonomy, then individual dignity, you need not have any constitutional framework because constitution has left it to us. Constitution has left it to us because we, the people of India, we assure as far individual dignity is concerned. And the framework, see, is not for the constitution because there is this fraternity and dignity. They are used only in the preamble and they are not used anywhere in the constitution because they are deliberately put by Dr. Babasaheb Ambedkar. They were not made subject to any discussion or any such thing. After all, to keep others' dignity, madam who has asked, you need a constitutional structure. Are you treat your servant maid, see, at least with honor. For this, you want a constitutional mandate. Others see your fundamental duties. Fundamental duties are meant for you. Okay, go ahead. Next.
So the next question is the constitutionalism weakened by frequent amendments?
Dekho, constitutionalism, see, is something. You said I didn't. It is not. You see, a provision to be amended. You see, it is a process. It is not a product. It's a process. Take for example, transformative constitutionalism. I said it is see, indirectly amended the constitution. Otherwise, where it is your education is a fundamental right. Or see, they have got sometimes to illogical end. Article 21 includes the right to live, includes right to death also. Can it be formalized? See, it is totally, it evolves. It's a process, it's a dialogue, what we call dialogic judicial review or dialogic jurisprudence. It's a constant interaction between the public and the judiciary, and from out of it no, comes out what's a norm. And that is how India is the only country which has developed this norm, that is education as a basic right. And that has become a constitutional right and that has become fundamental right. That is the realistic constitutionalism where uh, nothing, it has become a norm, then it has become almost a fundamental right. That is how it has evolved. Okay, next.
Yes, sir. The last question is, as you mentioned that a lot of ideas of Chanakya have contributed to our constitutionalism, yet why do not we recognize ancient works such as Arthashastra and Manusmriti as the primary sources of our constitution?
Because he's Indian, because he's an Indian. See, so much of jurisprudence we study, we start only with Greek. We start with Plato, then see Aristotle, but we never bother about our own people. We have, yeah, because we don't consider them see as capable of being see included in our syllabus. This is what Westerners have said. In fact, the Germans have see much more. They have studied see much better, and they have translated all these works. And now it is they who are actually opposing all English ideas because writings of Maine and others, no, who have see actually uh, rather see they have shown the entire see Indian jurisprudence very very bad ships, and you can see Werner Minsky, who has made who came to India, who studied Sanskrit, and we have see actually he translated all these books into English, and he said, you see what Duncan Derrit and see so many others know, including Maine. He has made a devastating criticism about see the foreign authors who have condemned see, our Indian works. So this unfortunately that is see, we were made we are deprived see, of learning these people, and I think see the educational policy makers know they have to do something for this one. Yes, you have to study, you have to make them popular, and the governments also should take care of it because we have more secular governments. So we don't want the Indian history to be studied more seriously. We want to study only British, etc., etc., and nothing else. What happens in Rome, we know, but what happened is in Pataliputra, we don't know. What Chanakya had written, we don't know. This is our education policy. At least we must really thank our great Babington Macaulay, because who has not made us know to study all those things. So we speak English, we walk English, we talk English, we drink English, but we never even touch Sanskrit. How many translations are there for Sanskrit? But there are more German translations of Sanskrit words than you see Indian languages. I think I hope
Yes,
this is
sir.
a post-lunch session is enough. Have a good tea. Have a good tea. Have a virtual tea for me.
Thank you, sir. The questions have been answered. Now I request our Dean, sir, Dr. T.R. Subramanya, sir, to address the gathering.
Respected Professor Emeritus, Sri Dr. Lakshminath, and dear colleagues and my dear students, you have heard one of the best lectures, and it is a hard nut to crack. Unless you know the history, unless you know the constitutional history of India and the subsequent developments that have taken place, I don't think you will be in a position to appreciate of what the Honorable Sir has said. Now, regarding Chanakya, he was just making a reference to how many of the universities in this country have made the contribution of Chanakya as part of their studies. Perhaps there may be hardly one or two, but whereas in Germany and in other places, it is being studied. I still remember once when I was working in Bahrain, I saw a book, and the name of the book is Hindu Dharma. And this book was written by none other than the present head of the Chinmaya Mission, by Swami Tejomayananda. And later, at the end of the book, the backside, it was indicated that this is a prescribed book for the secondary school of education in the state of United States. That is how they learn our culture, they learn our traditions, they learn our itihasas, they learn our Puranas, whatever it be. Now, I was reading a book long ago when I was maybe in the 1960s and 70s, 60s and 70s, maybe. So at that time, I came across a book written by Sardar Panikkar, K.M. Panikkar. Now, Sardar K.M. Panikkar happened to be an IFS officer. He was the Indian ambassador to the state of China. The name of the book was A Brief Survey of Indian History. Now, in this book, he makes a reference to Chanakya. I still remember the quote. I just put it to you across so that you understand the point better. If the Indian administration of today is analyzed to its base, the doctrine and practice of Chanakya are still to be found in force. Now, he has said it 50 years ago, but then today, today's teachers don't even make a mention of the contribution that is being made by Chanakya, although it was referred and expressed very proficiently by great men and thinkers of the time. This is how all in all issues, it goes on like this. Now, as regards the other developments, it was put in such a classic manner, in a precise manner, in a lucid manner. And a student of law will be able to appreciate the point much better. And those students who don't understand, I request you, when the video is put, listen and re-listen and listen again, so that you'll be in a position to understand at least a bit of what the Honorable Sir has said. Sir, I sincerely thank you for having accepted our invitation and for being with us and for enlightening us with your talk for more than an hour. Thank you very much, sir.